Right.
No,
But that's
I
not
found it
to
on-
be determined. That's
We intentionally waited 5 minutes for that exact reason. All right, I will go ahead and call the meeting to order at 7:06. I will entertain an approval of the agenda. All right, Dr. Prithridge with the
Second.
motion, Vice Chair Rosenberg with the second. All those in favor?
Aye.
Any opposition? Seeing none. Approval of the minutes from March 12th. Any additions, changes, corrections to the minutes? Hearing none, I will entertain the same motion for approval.
Second.
Okay. Whichever one of, whoever you want to give the second to. So, motion and a second. So all those in favor of approving the minutes as presented, say aye. Any opposition? Seeing none. At this point, we'll do public comments related to items that are not on the agenda. So if anybody from our 4 visitors would like to, we actually decided to get the podium. To get the podium, Pete.
Not that you couldn't hear me.
Just don't push on it too hard. The top is loose.
So simply for
Peter
consistency in records. Yep, thank you.
6073 Contreras. I observed last month's meeting, and I thought you guys had some great points about, letting the outside people come in and have some good thoughts. But then you talked about who was going to be on the committee to pick all the people and some of the things like that. And I got to thinking about it. Right now, we've got a war going on, and we've got Israelis and Palestinians, and they don't agree. But the only way to get them to actually come up with a decent proposal and get everybody to settle on things is both sides have to come to the table. It can't be just one side. You can't have the city, and you can't have the landlords and some of the other people. You have a lot of people that you have a disagreement with on a regular basis, and they rarely get their opportunity to come and speak or to have a fair input into the process of how this is going to go. Now, I don't own rental property, so I'm out of that game, but I do know an awful lot of people that do. Right now, you've got probably about 5 major families in town that have been living here their entire lives, and they have a different opinion on what you might want to put into the zoning code. And we don't have a good way to have them invited or to make sure they're included, because a lot of them live just outside of the city or whatever, for whatever reason. But they still own half the city. And then they also own half the property immediately around the city. And if we want to expand to be able to follow the comprehensive plan, to be able to add businesses and many, many other things, just like the Palestinians and the Israelis, we have to sue for peace instead of battling on and on and on because of the way that one side sets the rules. David, you made some great observations last meeting about openness and inclusiveness and time. I understand Sam was making some good points about that, this is about financing and we've got to try to do this while the money's available. Well, that's all true. Maybe we can get the studies done, but when we get right down to putting this together, there's a lot of families in this community that have felt left out for a very, very long time, yet they own half the community. And I want to try to get that to somehow be addressed. Whether it's some real estate agent in town here that knows all 5 of them, or Scott, but Scott doesn't live in town either, I know, and all that, but bottom line is, yeah, he's in the donut, all right, but if the requirement is they have to live in town, well, then we have to pick somebody in town. If we can use somebody like Scott, he's a great resource. He's represented a lot of the people that the city has the biggest problem with. And I'm not trying to give you a job, Scott. I apologize if that's coming across that way. But somebody has to do this, and I'd like to see an encouraging statement from this board toward that to happen. Thank you very much.
Thank you, sir.
How you doing?
All right. Is there any other member of the public who would like to share their comments on something that is not on tonight's agenda? Seeing no mad dash for the LCMB podium, we will move on to reports from boards, commissions, committees, and staff. And we will start with our illustrious vice chair and simply go around and end with Mr. Perry, and then, or actually, yeah, I guess I only have HAPC, which you and I can both. So, tomato, tomato. Still
Sure.
yours.
So, Housing Advisory Commission did not meet last month, but we're getting ready for our May meeting by researching some of the housing stuff that might go along with the council work on like the strategic plan and a work session coming up. So that is what all of us have been tasked to do for this next month. So we're really looking forward to talking about that in May.
Perfect. Dr. Prithridge.
Well, I guess I might defer to staff because one of the major action items was the moratorium on the development of properties on the alleys. Were you going to talk about that, Sam, as a staff item? So council acted on that, but it was a staff initiative. And I guess I would just say that there was debate back and forth. I think people recognize that we had opened up in changing the code back in 2017 to allow properties with doors or entrances facing on alleys we started to get some development that had some consequences that we hadn't fully prepared for because we didn't have that development in the past. But I would say that there was general support for the kind of infill development that represents and the hope to get it right. So what was proposed as a 1-year moratorium was ultimately boiled down to a six-month moratorium with the possibility of extension. So it was a question about how it's the best way to do this kind of development. Like should we or not? And so.
Any report from the law department?
No.
All right. Ms. Webster?
Yeah, so I attended my first climate action committee meeting. And Mr. Prithridge was there too. It was a good, kind of longish meeting. The main topic was consideration that was proposed by staff to consolidate climate action and environmental commissions for a bunch of reasons. I think, and David, please fill in. Just that there's a lot of staff time that's involved, and in many ways the issues are related, complementary. And I believe the way it was left is a sort of subcommittee will be looking into it. There were different scenarios proposed, including keeping the two entities but making one a subcommittee of the other. So did I miss anything, David? That was the biggest.
Perfect. Anything from CIC?
Nothing to report.
Easiest report ever. Mr. Arbuckle?
So we had a parking and transportation meeting this morning, and mainly we talked about our budget priorities for council. And our top priority we've decided so far is the Main Street corridor redesign to make it a complete street multimodal corridor. And in addition to creating some redesign criteria for the future and for retrofitting streets when they're redesigned, when they're repaved.
Perfect. Mr. Bracken's obviously not here, but sounds like that was the discussion for environmental. Are you on environmental too? Okay. We had so much redundancy for years, I don't remember who's on what. So tomorrow we'll meet HAPC. I think the biggest thing that we're going to discuss is related to the Carolyn Harrison building. Sorry. Super long story short, the original proposal included the opportunity for them to have some garage door windows that would go up. I've read through it. I've compared with other things. They never installed them, and I would imagine that. Does that expire?
It was never approved.
I thought we approved
They
it.
never got approved.
Oh,
No.
okay.
There was discussion but no vote. So they're coming back with
Okay.
the final choice on their.
That's right. Their
design,
last submittal
Yeah.
didn't include it, so we didn't
which
have
was
it
2
in
years
there.
ago. So
Yeah.
I think there's been a lot of time that has passed.
That could explain why the final submittal didn't have it in it. But nonetheless, at quick glance, and again, we haven't heard the presentation, but at quick glance, some of the suggestions that we had put forth, for example, on college, they had proposed almost kind of, and just for lack of a description, if you think of like a swim up pool bar where it's permanent half and then the wall would come down, as I see it, the new one is a little more aesthetic and things of that nature. So that'll probably be the bulk of our discussion tomorrow at HAPC. We continue to work on cemetery tours, historic tours. Brad from the Lane Library System really helps out with that, as well as Counselor French. So that's HAPC. This is not a report, but I do want to piggyback something. Technically, yes, the moratorium was staff initiated, but I wanted to be very clear that I had talked to Sam about that and made a request. It just happened to be the formal request came through. It was a serendipitous agreement amongst a larger group of folks. So Sam had already had the conversation with the city manager, but I don't want there to be any illusion that it was a staff initiative. There was a lot of conversations from a number of people. The second point about the moratorium is there's absolutely no decision or definitive preference on development. It's just, and I think Dr. Perthridge hit it, is just a pause while we can recalibrate and get it right. And then that's not for the commission. I think that's for the greater good, that there is no desire to squash this. It's actually something the mayor, the comprehensive plan, a lot of things address alley use. So I just wanted to be clear that that is more of a stop, take a breath, recalibrate, then go.
Thank you. There was some chatter just before the meeting. We were talking about, Corey and I were about a railroad grade separation feasibility. So for anyone that was listening to that, I just want to get that in the record, that it was mentioned at the last city council meeting that the city engineer requested applied to participate in feasibility study with Ohio Rail Development, which is a division of the state government, to do a feasibility study in the Contreras and Locust area, railroad grade separation. So it's not a full design, it's not full funding, it's just the first step. There have been some other agencies in the area who have successfully gained funding for actually doing an underpass. So that's a big step for us. We've had it in our thoroughfare plan for a long time, but to actually start putting pencil to paper and seeing what it might, where it might happen and what it might impact, how much it might cost. So hopefully we'll have some idea on that later this year, and at some point it might move into design. But it's a very long process, probably talking many years, perhaps many decades. But we have to start at some point if it remains a priority of the city. So that's news. And transportation was also discussed at OPTAB today, to piggyback on Matt's comments as well. Just an overall transportation work. Short-term rental. So we have the two moratoriums going on right now. The one that has been discussed already with alley development, and then there's a short-term rental moratorium on any new short-term rentals as well. While we look at tweaking the code potentially, and we've actually applied for a May discussion with Planning Commission to make some changes for that and have that discussion as well. And then along with that, council requested some additional, more information to make an informed decision about that, to collect some data that we didn't have access to through our vendor, that would give us a better picture on the market as far as frequency, how that might be impacting the supply of affordable housing, so that the changes that council might be interested in making as far as in the zoning code, that they're done based on data in the market. And then zoning code update, those responses to the RFP that we have out right now are due April 24th. We had a pre-bid virtual meeting with 20 consultants last week, so there's some pretty good interest out there. It doesn't mean we'll get that many submittals, but we'll probably see some combination teams. It's zoning code, subdivision code, historic district design guidelines, so it's a really, really big project.
Plan development, does that lump it?
That's part of,
Okay.
that's part of planning and zoning and subdivision. So, so we'll, and we actually talked about some of the comments that came from Planning Commission at the last meeting, and definitely wanted to stress that there would be an expectation that an engagement component would have to be part of the proposal, and how the community can react and correspond and engage with the process. So we'll be looking at that closely. And I also wanted to say, for anyone who didn't get the email, apologize for the venue change. There's a trial that we found out about at the last minute just a few hours ago, and so there was a scheduling snafu between us and the court. And so rather than ask them to move, they had jury selection today. So it just made sense for us to move rather than them. They have a trial ongoing into tomorrow. So thank you for everyone's flexibility. That's all I've got.
Thank you, sir. So moving on to new business, PC 2024-01, conditional use for the new tractor supply. As you can see in the agenda we approved, it was voluntarily postponed by the applicant to the May meeting. So for all intents and purposes, it's a procedural administrative table that we don't have to vote on. But I just wanted that in the record vocally.
In the past, you have voted on it.
Do you want to?
I think it'd be best to have it in the record.
Okay.
I think
So I would move,
Yeah.
so we're tabling it or postponing, it's separate things, right?
Table.
Okay, we
Yeah.
can table,
Mhm.
okay.
Yep.
So I would move that we table PC 2024-01 until May.
All right, we have a motion to table from Dr. Perthrich. Do I have a second? Ms. Webster with the second. All those in favor of tabling?
Aye.
Any opposition? Seeing none, it is tabled on the table. Moving on, PC 2024-02, 219 West Walnut, lot consolidation. It's part of lot 202. It's 0.125 acres. Jim Clausen is the applicant. Seeing as Mr. Moore's not here when we adjourned to public session, I think Mr. Perry can take that. So I will entertain a motion to adjourn to public session.
So moved.
Second.
Dr. Perthrich and Vice Chair Rosenberg with the motion and the second. All those in favor?
Aye.
Any opposition? Seeing none, Mr. Perry.
Thank you. This may look familiar to some of you. This very plat was approved 2 years ago. However, it was not recorded, so therefore it's as if it was never applied for. However, we do have the historical record you need to be aware of. So anytime we have a lot consolidation or a lot split that involves less than 3 lots, it could actually be administratively approved. And so there's a set of decision criteria that's in the code, and if it meets all of those criteria, then you actually don't vote on those. They will end up on your agenda, especially for those of you that are newer. They will end up on your agenda as something that has already happened. So we've got some boards and commissions that do that kind of thing and report the results. And so it's essentially a meeting between staff and the chair or vice chair, whoever is available, to go through it, and then it would be approved if it meets all the criteria. And this same thing happened 2 years ago, and we made the determination that it did not meet the criteria. And so what the code says is that it will go to the Planning Commission for a vote. So that puts the criteria review in your realm to go through. And this time around, we did I should say Zach, and credit to him for doing the write-up on it that Mr. Watt and I signed. Of course, we went over it all together as well. This time, we did a very thorough review and analysis of everything, which we did not do previously. Last time the vote was close. It was 4-3. So there was a lot of discussion. It was a pretty lengthy discussion. And there's been some turnover in the commission as well. So the requirements, and I'll go through them. They're in your packet. The first two we have found, staff and commission chair have found that they are not met. And since all of them have to be met in order to be administratively approved, even if one of them was not met, it could not be approved. However, the purpose of the commission review is to determine if that was a correct decision or not. And so you can obviously discuss that. There is a moratorium on this very issue, but that doesn't. This application was submitted before that moratorium went in place, which means that this is still allowed to be heard and still allowed to be voted upon. And if it was approved, it could be recorded. So because of when it was submitted. However, because of the moratorium, if there was going to be a building permit submitted, then that step could not happen because that application would have been submitted after the moratorium is in effect. So
why wasn't it recorded to resume?
I don't know the answer to that. That's on the applicant requirement to do that. The city is not responsible for the recording. There's a 6-month window where after approval then it has to be recorded. So I don't know the answer to that, but there'll be a testimony time for that. We don't know that answer to that. So the criteria, and I will, I'm not going to read the report, but actually let me go to the aerial photo just for the sake of while I'm going through these. So there's 2 parcels, as you can see from the survey. And on the survey, you could see the lot line that we call that dissolved. It would go away, and those two parcels would be consolidated. So there's actually 4 parcels of land total, and there's a building that goes through the parcel lines. But the 2 that are being requested to be consolidated are the 2 rear ones that do not have any street frontage. And so that ties to the first criteria about fronting on a public street. So it does not meet that criteria. And some of these may look familiar for those of you that were on the commission at the time, where Zach actually did a kind of a comparison using what the buildable area would be without, because we were talking about whether the parcel was buildable or not, which is another one of the criteria. So that's just kind of a refresher on those. If it was consolidated, what the buildable area would be, and then if all 4 were consolidated. Obviously, these are not all options that you have available to you, but we just wanted to kind of give you an overall context, and that's not what's being requested. What's being requested is a consolidation of those rear 2 parcels. So you're not really doing like a site plan review. Some of you may be, used to doing that. We're not looking at a variance. This is just purely a consolidation using a survey and a determination of whether the criteria are met or not. And all of them would have to be met in order for it to be approved. So, and I hope you've had a chance to read through these. I'm not going to read this, but if you do make different findings than what the staff has, if you do make those, that's fine, but you'll need to get that in the record. Am I right?
Correct, yes.
Because of the staff recommendation with the Planning Commission chair is for denial, it's important that if it's a different finding that we have that in the record if you are getting to the point of approval. So the first one is the proposed minor re-subdivision lot split or consolidation is located, I'm reading from page 6 if you want to look at your packet. The proposed minor re-subdivision lot split or consolidation is located along an existing public street and involves no opening, widening, or extension of any street or road, and in the case of residential lots, does not involve the creation of any easement for access. So that first, the first issue there in the second phrase, located along an existing public street, it is not. So that's the issue with that one, where it's not in compliance. And I'm not going to read the rest of number 1. Going on down to number 2, the minor re-subdivision, the proposed minor re-subdivision lot split consolidation, still on page 6, meets the dimensional requirement of the underlying district, which in this case is 6,000 square feet, or a minimum of 3,000 square feet of lot size if the underlying district does not have minimum requirements. So this does not meet the 6,000 square feet, so it doesn't meet that either. And that would be 5,465. So it's short. And then the other ones, all the other criteria, we have found to either not be applicable or they're met, essentially. So happy to answer any questions. And of course, Mr. Clausen, the applicant and property owner, is here as well. And he or some of his colleagues may have some comments to make too.
So at this point, does anybody have any questions for Mr. Perry?
I'm just trying to understand, to what degree is this question specific to this parcel, and to what degree is it effectively an interpretation of the code?
It's only specific because this is unlike BZA. And that was actually a question that Ms. Etta Reed had asked over the phone. It's a great question. I'm glad you brought that up. Because in the case of BZA, where there's an interpretation difference, that can apply broadly to similarly situated. Like if there's an appeal of an administrator decision, that could be broadly applied if there's a zoning code interpretation. A variance would not be, because that would be specific to a single site. So this is neither an appeal of administrator decision or a variance. So this would be specific to this one case.
Okay, but substantively, some of the questions are general questions
Correct.
about the definition
Correct.
of a street, for example.
And what we have done with other boards, specifically BZA, if we have repeat issues with codes, then that would behoove us then to annually review the code and then bring a change to council if there's a difference of interpretation that needs to be resolved.
And then the second question is, if we're interpreting the code, so there are various codes that are at play here. One is the subdivision code, and this is a lot split under the subdivision code. So there's a moratorium that's on everything, on minor subdivisions, major subdivisions. But effectively, this doesn't say anything about the ultimate. There's a moratorium, but for example, if this were permitted to be consolidated, it doesn't, for example, entitle them to the right to build, or does it? Because the code, for example, right now is suspended. The zoning code is suspended.
It does not entitle a right to build until after the moratorium.
Yeah,
is
so
over.
the code, we
Yeah.
don't really know what the code is going to be like potentially after the moratorium. So this is just about the right to subdivide the property,
Based on
which
the
could
current
or
code.
could not entitle them based on the underlying code.
Right.
Okay.
That's correct.
Was this I believe this was the parcel, and correct me if I'm wrong, where the two wrongs don't make a right concept came up of there's 4 parcels, the building technically is on all 4 parcels, and subdividing any of it while leaving things that are still problematic. I believe this is the one where that came up. The reason I remembered is that fishtail 2 slides up is there was the 4-3 discussion. There was a lot of discussion about it's currently broken, making it less broken is still broken. As far as if this is consolidated, the building is still, yeah. See,
You want a pointer?
yeah. Actually, I'll get up. It'll be quicker. So right now, this is 4-way broken. This building is on 4 parcels. If we do this dwelling is still on a parcel, and I think some of the confusion is, well, they own it all right now, but if this ever gets sold, that house is on someone else's property. So it was kind of like the discussion, if I remember, was we can't make a decision or an action that is still wrong. We can fix things.
Because
but-
of the error that's already there.
yeah, we can't, if we're gonna make a change, it cannot grandfather in an error or kind of look a blind eye to something that's broken. That was kind of the discussion on this one. Has there been any other cases like that? I mean, this is 2 or 3 years ago, so I'm going off the top of my head.
We have had several cases actually in the Mile Square of building encroachment, and so they have, to my knowledge, they have not been lot split and consolidations, but they have been situations where you have a different owner, and the other owner either has already granted what's called an easement for that encroachment, or they are in the process of granting an easement. So there are mechanisms, if that was to be sold, to permanently allow that encroachment. It would still be counted against for lot coverage and those kinds of things. And there would be a spacing requirement for building code and zoning code, but using that as a means to justify the approval is not within the decision criteria.
Okay.
So I think that would be a separate, it's good information to be aware of, but I think you need to focus your, if I'm right, Ben, to focus your findings on what those decision criteria are, if they're met or not.
So the squirrel in my head, the building that burnt down next to UDF, when it was rebuilt, even though the old building encroached on the church's property, the new building could not. Is that a fair way to say, like?
Correct.
Okay.
Yes.
All right. Just wanted to make sure I understood that.
Just a point of clarification, is there a setback requirement? Let's just say this were something that could go ahead. Is there also, in this circumstance, is there a setback required from that existing building?
Yes. It'd be 10 feet.
Okay, thank you.
Minimum 10 feet. That's just the minimum. There's also a rear yard setback as well, because there's like it's based because of the alley. In the past, it has been treated as for that to be a rear yard setback. But whenever there has been an encroachment, there's at least a 10 feet requirement, perhaps more depending on what the yard requirement is.
So her question actually made me think of another question. So a corner lot, the postal address or whatever street it's on, like I have a friend who lives on a corner and they thought it was funny, so they petitioned to have their address changed to the other street. But basically, you get to pick one of the two streets to have an address. This has no streets, so where would the frontage be if it was approved? Because there's no street. You know, like on a corner lot, it's either the front door or the driveway.
But these are all things that are going to be addressed in the moratorium period.
Okay.
Because of some of those issues.
Okay.
These have been discussed for several years within the city.
Because you mentioned rear lot setback, and I'm like, well, which one's the front? Okay.
Mr. Prithridge has it.
So,
Oh, sorry.
I guess now I'm asking an interpretation question of staff's interpretation, because there's some language in here that Mr. Moore talks about, despite the change in zoning policy to allow entrances on front alleys, it's never been implied that an automatic right exists to custom tailor property boundaries to generate a new alley building site. And that if that were ever to be instituted, the impact on Oxford's development fabric would be devastating. That's a strong statement. So can you elaborate on what Mr. Moore is talking about? Because I feel like we're being asked to some degree to offer an interpretation on this very question. So the devastating part, like what are the consequences? Particularly if what we're talking about, this just applies to this, but it seems like we're being asked to make an interpretation of something for which there's ambiguity. So can you talk about that?
Can I interject real quick? Procedurally, because this happens a lot on HAPC, this is something that would come to the commission. However, there's a bypass if everything's copacetic.
Yeah.
So this is no different than anything else we handle. It's just when Mr. Perry and I looked at it, we didn't have a green light to do the procedural bypass. So this is no different than anything. So I want to make sure that's framed correctly. Is, for example, at HAPC, we're not going to convene over a wall sign that everybody already knows is compliant. So if it isn't, then it would be normal status quo. So think of it as like fast pass if things are good, normal if there's any questions, comments, or concerns. So I don't think it's any different as far as interpretation or anything. It's just when we looked at it, we didn't have.
Well, I think it's because
Check
there's
marks.
a debate about interpretation. Like it wouldn't, if there weren't a debate about interpretation, the check would have been marked on number one and it would be in front of us. So there does seem to be like a legal interpretation here, and I just trying to understand the yeah, what will be the consequences of permitting?
What that is about has to do with creating building sites by splitting and consolidating parcels that do not have street frontage. And so if that could be done freely, then there could continue to be additional buildings that have the issues that the reason for which the moratorium was put in place. Access issues, visibility issues, addressing issues, spacing issues, parking, setbacks, as Ann has asked about. Those are all things that these lots were really never intended to be built upon in the first place, but they have gained rights if they've met the requirement of the minimum square footage, and more recently have been developed to a greater degree. So if the free splitting and consolidating could be done without street frontage, then that would be devastating, because you could just continue to move lot lines closer to the street as long as there's enough setback, and continue to add more development, splitting and consolidating, as long as the minimum lot sizes are met.
But again, the philosophical difference is here is an alley, a street.
And it is not.
According to the internet, it's not.
Oh, okay, but but that's the kind of the question: is an alley a street? And the interpretation is that it's not. Okay,
I said that jokingly, but prior to making the decision, I did look
Yeah,
up.
looking at and definitions in our own code as well.
Yeah, Ohio Revised Code, and then our friends at Merriam-Webster and other straightforward sources.
And then we have in our subdivision code what we call cross sections, which show the dimensions of what a street is, what an alley is. 12 feet versus 20, 30, 40.
Drainage, sidewalks.
But I don't
Very
understand.
clear.
But as quite, I don't have the subdivision codes in front of me, but the report says the subdivision regulations define an alley as a minor street. Is that? I mean, I'm just. That's
It's a public right of way.
okay.
Yeah.
Okay, thank you.
All right. Any other questions for Mr. Perry? Seeing none, whoever from the applicant would like to come up, you can go to the podium. You draw the short straw a lot, Ms. Reed.
That's all right. That's all right. Good evening, Etta Reed, Bear Becker, 110 South College Avenue. Thank you for allowing me to be here tonight. Bear Becker, prepared that lot consolidation back in 2021 of these two parcels. And we also, with this resubmission, went out, updated everything to make sure everything still met all the requirements and the property ownership and everything was the same. As staff has indicated, it was approved by Planning Commission back in 2021. However, in response to your question, it did fall through the cracks. Essentially, it got approved and time just passed and it never got recorded, unfortunately. So we're here tonight to ask for it to be reapproved. This is the lot consolidation that we submitted is essentially the exact same one that we submitted in 2021 with the exception of a different surveyor stamp, and we added some parcel numbers. Nothing on the property has changed. The zoning code has not changed on this property. The only change that has occurred since 2021 was the moratorium that was approved and enacted last week. So these two parcels are two of the 49 that fell under this adopted moratorium. So the approval of this lot consolidation, all it does is allow these two properties to be consolidated. The one is already a buildable lot, the westernmost one. By adding the eastern parcel, you're really making it a better, more developable parcel. But we can't pull a building permit. The moratorium's in place such that we can't. So all you're doing is allowing us to consolidate two parcels so that when the moratorium is lifted, and we can agree, and we're agreeable, and we're ready to go, we can pull a building permit. But at this time, all we're asking to do is consolidate so that in the future we could potentially build a home once you guys have determined how, what the new requirements will be. And so really that's all I have. I'd be happy to answer any questions you have.
Any questions for Ms. Reed?
I don't know if it's for her, but there was, in Zach's comments, it's that the minimum, like, lot size, right, that is not met. So how was it approved previously?
So the westernmost parcel, because it's an alley parcel, it's over 3,000 square feet. So that's a buildable lot. And so we have just made it for a sense of a better term,
Would you like
a bigger,
Okay.
a bigger parcel. So we've just taken a buildable lot and made it better, more developable, more opportunity. So yes, it doesn't meet the 6,000 that the underlying zoning code requires, but the zoning code does allow, because it's an alley lot and 3,000 feet, we could build upon the one parcel. And Sam, do you have that one exhibit where we can go through it here real quick, where you show the buildable areas. So today, this is a buildable lot. This is the envelope which we can build in. When we consolidate the two, if we can go to the next slide, we have a much bigger footprint. And so that's what we're asking for the right to do, is consolidate these lots so we have this size of a footprint versus the skinny rectangle that we would have today.
Any other
To
questions?
build off of this question, to the 3,000 square feet versus the, I'm seeing new single-family dwelling is the 6,000 square feet. Would this be permissible as like an accessory dwelling unit, give under the 3,000 square foot
No.
rule? No. Okay.
Accessory dwelling units are on a lot with another building, unless it's through conditional use. Yep.
Any other questions for Ms. Reed? All right, seeing none, thank you. Are there any comments from the public on this matter? Just a refresher, you will be on the clock for 3 minutes. At about 2:45, I will let you know you have 15 seconds left.
Okay.
If you give me 1 second. All right.
Okay, so I just wanted to make a couple points here this evening. Oh, I'm sorry. Scott Webb, an architect in town, 103 West Walnut Street. I wanted to make a couple points on the back of what Ms. Reed has said. We are here tonight simply to combine lots. It's typically a survey exercise. It's a simple recording of joining two lots together. It appears to me that this discussion, though, has veered off into more of a policy question, more of a referendum on do we want alley construction and things like that. In the first place, I don't think that's really the issue at hand tonight. As Etta pointed out, we're not creating a new buildable lot in the alley. There is a buildable lot in the alley. We're just creating an opportunity to make a better lot in this case. And so, as I did at City Council in light of the moratorium last Tuesday night, I would like to remind Planning Commission that this idea of building in these alley lots was something that came from Planning Commission in our last code revision. We talked specifically about the vacant lot in the center of the blocks. In fact, you created a whole new zoning chapter to create accessory dwelling units to encourage development in buildings behind other buildings to use this lot. So while we're veering off into a policy discussion here about this survey issue, I think that it's important to note that I think this policy issue has already happened. And secondarily, when I made the points Tuesday night at City Council, I think it was pretty evident that City Council, 6 of the 7 that spoke that night, were in favor of alley development in general. Yes, there's work to do. Yes, we have a moratorium in place to find that work to do. But preventing a simple lot combination tonight while we do that work, I don't think is really the issue at hand, and I don't think that's really fair to the applicant, and I don't think it's fair to the goals of City Council. If you are encouraging these kind of developments, if we do think this is land that is available to be developed, infrastructure's in place, less parking, adjacent to the university, all the reasons that you decided to do this the last time, shouldn't it follow then that rather than hamstring this client and say, we're going to make you stick to this tiny 3,000 square foot lot with a really dumb little footprint, we would rather keep you there than to improve this lot to something and have a better development. If you're encouraging development in the alley, I think you should be in favor of encouraging better development in the alley And so I would ask you to go back to the question of just, this is a simple lot consolidation. It's not a referendum on building in the alley today. But if City Council and Planning Commission has been in favor historically of building in the alley, we've got some time to figure out how. And so now we would just like you to consider, if you would like buildings in the alley, give us an opportunity to make a better one.
Thank you. 3 seconds to spare. Nicely done. Are there any other members of the public? Looks like Pete, could you reintroduce yourself, please?
Sure. Peter McCarthy, 6073 Contreras.
All right, you're
It
on the
would appear
clock,
to me
sir.
if we have 49 of these oddball lots in the square mile, by combining two, then you only have 48. That's a big win-win for the city, because then they can't come back and ask to build a separate one on that. Looks like it's a simple decision.
Shade under 15 seconds. Thank you, sir. Unless there's anyone else, Ms. Reed, if you'd like to be a member of the public now? Okay, perfect.
I have one thing I want to add.
Are you a member of the public right now?
I am not.
So, seeing as we're done with members of the public, I will accept a motion to adjourn from, you can still talk and staff and board. I'll accept a motion to adjourn from public hearing.
So moved.
Dr. Perthridge with the motion.
Second.
Mr. Kruth with the second. All those in favor?
Aye.
Any opposition? Seeing none, Mr. Perry.
I would just like to add to Mr. Webb's comments. For those that are new to the commission, there was some work that was done in 2017, which rezoned large portions of the mile square, the eastern half of the mile square, not this part of the mile square. And there was also some changes to the zoning code to facilitate accessory dwelling units in the R3MS district, which is not this district. So there was effort to look at how do we take advantage of the land resource that's available near the university, and what are some methods and some tools that can provide that opportunity. There have been a few projects that have been done since some of the zoning standards in the mile square were lessened. So lot coverages were increased, and I believe there's some setback changes as well, which did help facilitate some new projects. And the R3MS then became a method to have an accessory dwelling unit. So through a conditional use process. So that was the history on that. So that's about as far as it went, and we didn't see as much redevelopment as we thought. I think a lot of the student housing that had happened on the outside of the city, had added a lot of supply at that point. So maybe it was a little too late, but it did help some projects to happen.
So normally I go last, but I do want to frame this conversation. I think there's an impression, or at least a persuasion, to have us think that this is a discussion on the policy. It's not. So again, if you have questions that pertain to it, the moratorium's irrelevant, but the decision criteria are. So if a discussion about the decision criteria is not a discussion or a referendum or anything as it would be presented. Also, just for the fruit of those who are going to read the minutes, accessory dwellings have to have a primary dwelling. So reference to accessory dwellings, a garage is an accessory dwelling. So use of accessory dwellings or additions of those in alleys is not the same as a primary parcel. So just for the good of the order. All right.
So, I'm pretty confused at this point. So what is before us is if we're approving a lot consolidation or not, right? Pure and simple?
Yes.
Okay. And what are the limitate, I mean, I know that we have the 7-point document, but I'm a little confused about the 6,000 square feet, Because clearly, if the lot is consolidated, you can meet the 6,000 square feet.
No, it would
No,
be,
it's
it would be less.
5,400.
But if you wanted to find, if you wanted to make a finding that it met the spirit of the code based on the testimony or the overall intent of the code, you could say that we know it doesn't meet 6,000 square feet, but we believe the consolidation would meet the spirit of the code. Therefore, we're waiving the requirement in this particular situation. You could do that as a commission, but you would have to make that finding different than the staff report. And then you would still need to deal with the street frontage, which you would have to make a finding that an alley is a street in this situation. Therefore, we are making a finding different than the staff report. Or the staff report talks about a couple different options there. You know, and Dr. Prithridge mentioned, you know, that in one place it's mentioned that an alley is a minor street. Okay, in another place it's not. So which is it? So you could make that decision if you wanted to for this particular case. And you could say, in this case, we believe that it meets the spirit of the code, and we're going to waive the street frontage requirement on Walnut Street and make the assessment that alley meets that requirement. So those are both things that, as a commission, you can discuss the pros and cons of that, and you can make that finding in this case. So I think that's fully within your power to do that.
Dr. Prithridge.
So I'm struggling with this both at the spirit level and the letter level. I having been part of those conversations, when we revised the code, the overall thrust was we were worried about growth and demand for student housing, and we really didn't want to see peripheral mega developments. So the question was, how can we feather in density within the mile square in such a way that doesn't result in wholesale demolition of the fabric? And that's why we lean towards the ADU, because it added density as an addition to these historical structures, as opposed to people consolidating the lots and, bulldozing them. And although we focused on the ADUs, I think that was the overall spirit, which was how do we add density while maintaining the urban fabric. So that kind of leads to the question of alley development. There was a whole other little conversation that, I think we ended up with the principal frontage requirement opening up to not just on the main street for other reasons. We had commission members who were like, that's just dumb. Like, why do we need to do that? Some of us are traditional new urbanists, and we're like, no, it's got to open on a main street. That was relaxed, I think, for a somewhat different reason. But I would say the overall thrust is that our alleys are underutilized, and done right can add density. I just was walking up Walnut, and it's an effing disaster. Parking lots and cars, I'm not sure that preserving a lot on the alley is the highest and best use of the land in the mile square. So, do we have issues with the lot splits? That doesn't mean that all lot splits are going to be good. It doesn't mean all development on the alley is going to be good. But I'm a little shocked to be like, I feel like it's ultimately an interpretation question about what is an alley a street. If this is a subset of this, if we're talking the subdivision code, and I trust the analysis that's here, the lot split or a minor subdivision is part of the subdivision code, and it's quoted here as saying an alley is a minor street. So within that code, if there's ambiguity between this code and the zoning code, I think you got to look code by code. So if the subdivision code says an alley is a minor street, and the criterion is the proposed minor subdivision is located on an existing public street and involves no opening, widening, extension, and that's a whole other thing. The whole idea is they're minor lots because they have existing. We're talking about not having new streets. If there were new streets, then it would require a subdivision. But this doesn't require new streets because it's on a street as defined by the code. So there, I'm struggling with both the letter of the law. We say we want alley development, and the code says that an alley is a street. As for the dimensional requirements, it seems also that it meets the letter of the code because the 3,000 square foot one is buildable. So, I guess I know I don't want to disagree with staff, but I'm just like, it seems to me we're wading into, if alleys are not buildable lots, that's a really big question that we just waded into, and I don't feel like this lot split, I feel like that's a code question and not a lot split interpretation question.
And it's a consolidation.
And it's a consolidation. They could consolidate all four of these things and build something else, So like, I'm not. And again, we're just a lot consolidation, so it doesn't mean that under whatever code we adopt after the moratorium that it's necessarily big enough or anything. So we're not vesting them in anything other than the ability to consolidate them in the hopes that in the future they can develop it. But I feel like we've been asked through the conversation about a lot to support an interpretation of the code that's pretty fundamental. And I'm not sure what the right place for that is. But it doesn't feel like a lot consolidation conversation is the place to adopt an interpretation of whether an alley is a street.
I agree with you completely. I think that I agree with Scott that this is just going to be way better to develop. And in fact, with the existing building, if they're together, maybe an ADU could be built. I agree with you. It just seems like we're bringing something into this conversation that is bigger than what we're dealing with tonight.
So Ms. Reed said that there was nothing new. I don't remember if Mr. Moore included it, but I do know that the fire department has expressed concern about alley development because, again, if you look up alley, it's a narrow path preserved for pedestrian and/or service use. A fire truck is really hard to get down there, and part of the, you said the 3,000 is buildable. This is where the less broke theory comes in, is if we have to make it 6,000, regardless of what it is, if we have to make it 6,000 and it's not 6,000, it's not there. So that was one where it didn't meet the criteria. Also, I don't remember if you were on the commission when we had the riveting conversation about porches, stoops, and decks. There are actual definitions for these things. We can say, oh, it's a street, I drive my car down it. Well, I've driven on a bike path before. It doesn't make it a street. So that's where, when I looked at it, I didn't just do this flippantly. I actually did a lot of research on definitions. To the best of my unrecycled pile of agendas, I went back and looked at this. And it was a 4-3 vote. I believe Dick Keebler was on, and he was extremely concerned with fire trucks and access and things of that nature. And again, while this may not be under the moratorium, and I feel like there's a bit of a sales pitch of like, don't worry, there's a safeguard in place. It's about time for my word perpetuity. So I know that in my experience in Oxford, people think, I can do this and it doesn't set a precedent. It does. So regardless of a moratorium or not, because the moratorium's irrelevant, real quick, I was pausing to think. One could argue we don't know the definition of a street or things of that nature, and one could also argue then we should intelligently not make a decision without clarity on those things. I think right now people are like, well, there's a lot of ambiguity, but there's also not clarity.
So instead of 2 lots that don't work, there would be 1 lot that doesn't work.
Again, keywords doesn't work.
But I don't believe that either. I know that alley is a street. I've been on that alley, driven on that alley. I know that alley is a street. So, you're saying like pedestrian traffic and all that, that is used as a street. And then if we have in the code the definition, that's a street. There are parking and driveways off of that.
But from a policy and legal standpoint, if there is conflict, you in code, you can't say, "Well, I like this one better," and I think that's what I'm hearing.
No, I
Is there
can't because
any
I'm making an
ambiguity?
interpretation.
I mean, and even in the zoning code, which I don't think bears on this in the same way the subdivision code did, and I know that was unclear, it said every building here and after converted shall be located a lot of record and how shall have its principal entrance on the street. For the purpose of the provision, alley is not considered as a street. Okay, well maybe you're right, except for the lots that are considered alley lots with only alley access that may have its in principal public entrance on either alley.
Which is there right now.
Yeah,
Right
I mean,
this second.
I'm not sure. I don't see where the ambiguity is in the code, whether or not they're safe to develop and whether the setbacks. I mean, that's a zoning question.
And we are the zoning plating commission for the city of Oxford.
I know, but that's a separate stage. I don't understand this conversation.
Yeah, so I just, besides everything, it seems like our charge is narrow. Do we want to allow lot consolidation or not? Period. End of story. And then, not for nothing, there are alleys all over the city of Oxford that are functional, that are doing well, that are part of the fabric of this town. And most of them are commercial as far as I understand, which, is a different kind of burden, so just by the way. But I mean, I just think that what we're supposed to do is decide whether we want to allow lots to be consolidated and leave it at that. And this thing will go through its paces if it comes to fruition.
Well, and part of also why we denied it or at that stage declined it is there's decision criteria. So it's
Well, let's go through the decision
yeah, let's
criteria.
go.
I mean,
so that was a breath to
Let's-
pause, not an invitation to interrupt.
But-
So in decision criteria, when we look at it, it is 90% of what the code asks for. So it's yes, no. There is no kinda. And with the alley, as things stand, if you were to do a GPS of this, it will not show you the alley. According to GPS, the Postal Service, you go down the list, it is an interior ancillary property. And I understand what Ms. Webster's saying. This is where, and maybe it's too legalistic, but if you think about it, part of where we've gotten with some of these problems is we're using, and these are my words, we're using emotional, like, well, people already do it, or, like, if there's a dirt road on a field, it doesn't make it a street. It's a 2-track on a farm. So that's where the legal definitions, and again, having lived through this stoop porch deck conversation of what the difference is, that's where I think the charge of our board is, because historically there are people or boards that have. So the way I've always growing up in government is, if the speed limit's ridiculous, it's still the speed limit until you get them to change it. So, and that's where I think we've gotten ourselves in a pickle, is over the years there's been, variations, but that's the perpetuity I talk about, is prior decisions or interpretations that aren't necessarily grounded or founded are where decisions are made. So that's why I'm trying to make sure we're extremely intentional on this one.
You want to go through the 7?
Yeah, absolutely. All right, starting with the first one. The proposed minor subdivision lot split or consolidation is located on an existing public street involving no opening, widening, or extension of any street or road, and in the case of the residential lots, does not involve the creation of an easement for access. Obviously,
Are we doing a little straw poll on whether we think the criteria has been met or not? Is that a good way to kind of?
we could. One thing I'd like to point out is my concern about the crosshairs in the middle of the building. Mr. Perry mentioned a need for an easement, so that was the secondary outside of the street, was there would need to be an easement potentially.
Not an easement for access.
Yeah, it's just an easement for if they decide to sell that property.
Right.
It's not for access.
Okay. So, what's the general inclination? Is Hogan's Alley a street?
I believe criterion one has been met.
All right. Let's see. Number 2, I'm trying to remember. Number 2, the proposed minor subdivision lot split or consolidation meets the dimensional requirements of the underlying district or a minimum of 3,000 square feet of lot size if the district does not have a minimum lot size requirement.
But then there's this secondary thing inside of there. So so there are like 2 levels to this. One is it should be 6. But if it's an existing lot, it can be 3. Is that?
No.
So
No.
what's the second? Can you talk through this code because it's confusing. I mean, the code would suggest it has to be a minimum of 6, but then it says here that the threshold can be overridden where pre-existing lots are involved.
That would be,
Actually,
if
it's
you want a
the other
building
way.
permit on a lot that's under 6,000, as long as it's 3,000, we give you the building permit.
Okay.
That's not a lot consolidation question. That's just saying you can use it as a buildable lot.
for the 3,000. Okay.
Right. So that was more for context.
Well, it's also if there's no other. So, Dr. Perthridge, how I heard you, you said it backwards. There is a minimum of 3,000 unless there's a differentiation by the lot, and there is in this district. So it's not 6,000. It's not the lesser of 2 evils. It's
I know, I'm
3,000.
trying to read the
yeah.
code, which is confusing. So it meets the dimensional requirement, the underlying, which is, in this case, the underlying district is 6,000 feet.
Yes.
Or a minimum of 3,000 feet if it does not, but there is.
Mhm.
But then inside elsewhere in the zoning code, under section 1137.05, is that a lot in a residential zoning district does not satisfy the site development regulations may be erected, and
That's not part of the lot consolidation criteria. That's just saying if you have a 3,000 square foot lot, which is not conforming, you're allowed to develop it.
Right.
That's all it's saying.
But in this language of section 2, it ties the minor subdivision to the zoning code, right? I mean, when it talks about the dimensional requirements of the
For the
underlying
minimum
district,
lot
it's
size.
talking about lots. So this is a place that cross-references the 2 codes.
No.
Well, when we talk about underlying district, what are we talking about?
You can make that cross-reference if you want to. Staff have not.
But when it says the proposed shall meet the dimensional requirement of the underlying district, district refers to districts in the zoning code, right?
Right. 6,000 square
Which is
feet.
6,000 square feet.
Yes.
But the dimensions in the zoning code are specified in 1137.
That's non-conforming.
Okay.
That chapter is only
Okay,
non-conformities.
that's what I'm just trying to
That's all it
understand
is.
this here. So it is
That's all it
tied
is.
to the underlying zoning district, which is 6.
Correct.
So
But-
why is the reference to
But the
1137?
consolidation would be 5462.
The final result would, yeah.
5465,
So it
yes.
doesn't meet the dimensional requirements of the underlying district.
But we're allowed to propose that be waived.
Yes.
Okay.
You can. You would have to cite your reasoning, and there
Okay.
would have to be a majority vote, but yes.
So I'm just going to say,
Am I
now
right
that
there,
I
Ben?
understand that there's, yeah.
Is that
Correct,
okay for
correct,
them
yeah.
to do that?
And so when you, as Sam has said, when you make your decision, if it's going to differ from staff, I would cite specifically, what is your rationale for differing, right? The facts and spirit and intent, for example, could be a reason, as Sam has mentioned.
But they're not variance standards.
They're not. Yeah, you're right. It is not correct. It's not a variance question or issue. That code doesn't apply.
So if there were an argument to be made, I think it's just that historically our zoning code revision, and I'm not sure which portion of the code this ties to, tried to impose fairly suburban standards on the mile square. We set, 20 years ago, people set the lot thresholds relatively high, lot coverage standards relatively low, and I think we've started to back out to it. So I don't know whether 6,000 or 5,500 feet is an inappropriate standard, but it's greater than 1/10 of an acre, which is probably not that small of a lot size for a like you're the urban designer, right?
Yeah, that's funny. Yeah, funny big. Sure.
The other, for reference, this isn't open to the public. The other thing too is when we as planning commission and for the most part BZA, the variance is not on the size of the lot, it is on the coverage of the lot. Very rarely, the only time I can think of, and I may be wrong, was out by the country club where there's ridiculously large suburban R1, 10,000 square, they went to 8. So that's the only time, and that was widespread planned use development. I can't think of a single time in the 7-ish years, in the decade I've lived here. Lot coverage is something that we've adjusted because of trees, usage, topography, but never the size of the lot. All right, so straw poll on that. Who thinks that criteria of 6,000 square feet is met?
If it's to our discretion, I would say the spirit
Spirit.
the spirit
The
of the
spirit.
code is met.
So my challenge would be, how is it met?
And if I could just say something, and Sam, correct me if I'm wrong here, I think also part of the language that you can rely upon to justify this, if you decide to do so, it's substantially met, right? I mean, are we talking?
Yeah,
whether or not-
substantially would be fine.
So I mean,
Yeah.
I think you could say, you know, to the extent that you're not comfortable with saying necessarily maybe that you're waiving it, I think you could maybe say it's substantially met if it's close enough. Because I think that is the language that's used substantially. I'm not telling you which way to go with it. I think that's something though that you could cite in your rationale potentially.
I mean, if the purpose of our recent code revisions, which permitted some development on alleys, was to perpetuate the fabric of the mile square rather than its demolition, this is of a scale that reflects the existing dimensions of traditional developments.
All right, so again, who thinks that this criteria has been met or substantially met within the spirit? All right. Number 3, I don't believe that was relevant. I'm trying to remember if this was.
I mean, the whole thing about the properties, the buildings sitting on the multiple lots doesn't seem to fall under any of these building criteria, which could be, I mean, is that not a problem for a lot split? You know, that we have a building sitting on a separable lot? I mean, that doesn't fall under any of the other
I mean,
criteria, but.
it just,
It doesn't now because it's the same property owner, but
yeah.
being the
If it was a different
forethought
property owner, it
person.
would be a problem.
Okay.
So that's also where my concern is today that it's the same property owner. You know,
But they couldn't.
a probate court decides they're two separate, you know, now that's the decision. New decision creates new problem. So number 3, the physical characteristics of the property are suitable to build. Everyone think that's agreeable? There's no division or allocation of land for parks and open spaces required by these regulations. New lots created are 5 acres not applicable. Sale or exchange of parcels adjoining, I don't believe this one.
No,
It's not applicable.
No.
And then it's not creating more than 2 lots. All right. Well, if somebody would like to make a motion and someone's willing to second it, we will wordsmith it from there.
Some motion for approval of, just close my PC. Whatever it is.
It was number 2. PC 2024-2.
So moved.
Okay. Motion and a second. Before we vote, because this has decision criteria and because the staff report and chair indicated it didn't meet criteria, I'm asking that the motioner and seconder craft language that will be suitable to explain the variance from the decision criteria not being met. No, yeah.
Yeah, I
If we
believe
vote on it.
that, certainly I believe that the proposed minor re-subdivision lot split or consolidation meets the dimensional requirements or substantially meets those requirements since it's 5465 square feet instead of 6,000.
And I would also add that I do not believe the commission is prepared to interpret an alley as not being a public street. And so if, under the subdivision code, we interpret it as a minor street, that we respectfully disagree with the finding that one was not met, and we found it to meet the definition of a minor street as specified in the
So,
subdivision.
point of clarification, if the commission's not making a determination one way, are they making a determination the other way inherently?
We're interpreting the code as I think it's just a different interpretation of the code than we met the definition of a public street under the subdivision code.
I think that's sufficient in the record.
Okay.
I think that would be
That
sufficient.
explains your justification.
I appreciate
for
you,
voting in this fashion.
asking for that, because it's good that we have that in there.
Okay.
Yeah, I think that's,
I agree.
All right. Will you call the roll?
yes. I'll start to my right here. Mr. Arbuckle?
You have me first to vote. So, I'll vote to approve.
Okay. Thought you had another thought there. So
I was looking forward to
He's not sure, none of us are.
Okay. Comment with that, but I'll keep going. Mr. Creed?
Approve.
Okay. And Ms. Webster?
Approve.
And Mr. Prithridge?
I vote yes to approve.
Ms. Rosenberg?
Yes.
And Mr. Watt?
No. All right, so the motion passes, and will this go on to council, correct?
It will not.
It will not? Okay.
No, it does not need to.
All right. And with that, I will gleefully entertain a motion to adjourn. Dr. Prithridge with the motion. Ms. Webster with the second. All those in favor?
Aye.
Aye. All right, any opposition?
It's not about you.
All righty.